One of the parts of my article that was not in the assigned reading was the background section, and I'll just provide a brief summary of that, especially because I know some of the clerks who were in the room earlier also just hadn't had a chance to look at some of the papers before they came. In 1813, this is the first case that dealt with where we have a recorded decision of a religious exemption, and it's where a Catholic priest received an exemption from subpoena powers in New York, and he was being subpoenaed to testify about confession he had received of stolen jewelry. And the court ruled in his favor, and we know in part what the court said because William Sampson, the attorney in that case, kept pretty detailed records about that. It's not until 1878 that we have a case applying the federal free exercise clause against the federal government, in part because Utah is a federal territory, and so that's why it comes up. And in this case, the court denies a religious exemption. It's always fun teaching this case in Utah because a lot of people are related to the folks in that picture. So one of them was like, that's my great-grandfather. So anyway, after we have incorporation, some of the first cases we see dealing with free exercise clause, that ultimately became more known for speech cases were the twin flag salute cases in the 1940s. And so in Gobitis, the Jehovah's Witnesses who did not want to salute the flag brought both speech and free exercise claims and were denied. And then in Burnett, a few years later, the court reversed course and didn't really give a clear test for what would govern religious exemptions and really spoke eloquently in terms of compelled speech. But we provided protection for the Jehovah's Witnesses from an otherwise generally applicable rule of the flag salute requirement. So it's not until Sherbert v. Werner in 1963 that the religious exemption framework really is wedded with the strict scrutiny framework. A lot of scholars say strict scrutiny didn't arrive on the scene at all until 1963. NAACP versus Button is another strict scrutiny case in this year. Then we have Wisconsin versus Yoder, where the Amish were given a religious exemption from a generally applicable public school requirement and were exempted from sending their children on to high school. And then scholars debate how robustly religious exemptions were actually protected or offered by courts after 1972 and up until 1990. But in 1990, Justice Scalia, in his famous opinion, reversed course and went back to a framework where he argued that if a law is neutral and generally applicable, essentially it only gets rational basis review, with some exceptions, but that aren't important for this paper. And he talked about how a religious exemption would be a constitutional anomaly and that we would be courting anarchy if we provided religious exemptions. He didn't provide a lot of historical evidence in Employment Division versus Smith, and Michael McConnell has some great scholarship sort of highlighting why that's problematic. Scalia went on later in his City of Bernie partial concurrence, to offer some historical justification for denying religious exemptions, and he relied on Philip Hamburger for some of those arguments, which I'll get to in a minute. But I want to just return to one of Justice Scalia's points that Hamburger has made and that Gerald Bradley at Notre Dame has made, is that we just don't have a lot of examples of religious exemptions during the founding period. And I think that that's true. In Michael McConnell's textbook, he has this summary of really where the states stood on the early religious exemptions. We had only 5 states that really decided the issue. You had 2 states that required religious exemptions. New York, that was the People v. Phillips case I talked about a minute ago, and Virginia. You had 2 states that rejected religious exemptions, and Pennsylvania was also skeptical in some ways in general of judicial review. We had 1 state that avoided the question, and then we had a federal court case. So what do we make of this historical question with this sort of lack of evidence? So Professor Hamburger has said, show us the case upholding a constitutional right of exemption. Why aren't they there? You know, if this was really understood originally to be part of the free exercise clause, we would have seen more evidence of that. And Bradley agrees with that, but I think takes it a step further. He says judicial exemptions would have left a measurable historical path. And he also talks about how really proponents of religious exemptions just simply misunderstand judicial review in general. The only power that the judiciary had at the time of the founding was to declare that a law was void or null, and that it really wasn't until an invention of the late 20th century with the civil liberties corpus of political morality and liberal individualism that we started having exemptions created. So I wanted to analyze this question of, number one, why don't we have a lot of evidence for this? And number two, what should we make of that? Does that really cut against religious exemptions? There's a lot of reasons, it turns out, why we shouldn't be terribly surprised that we don't have a lot of case law on this issue at the founding period. No, number one, judicial opinions were often not published in any sort of regular way. There was a low volume of judicial decisions about constitutional issues, period. There was a low volume of statutes passed. I thought it was a really interesting point Keith Whittington made in his recent Repugnant Laws book, where he talks about if we have judicial decisions in the numerator and statutes in the denominator, Congress has far outpaced the judiciary. And so by that measure, the amount of cases we have striking down on constitutional grounds today, we have far more judicial restraint than we did at the founding. And that's not even including in the denominator administrative agency policies and rules and regulations. Laws that were passed were also often private bills instead of broad, generally applicable rules. A lot of those broad rules came through the common law, not through statutes. That changed over time, but Farrah Peterson has done some really interesting work showing how the nature of statutes was different around the founding period. And then, of course, homogenous religious culture meant that there was less conflicts of conscience that were going to come up. And both Judd Campbell and Michael McConnell have written about that. So then the question I had was, what are some of the broader judicial norms then that governed, given that we have this lack of evidence? And it turns out that I think there's a lot of equitable or broader norms leading to equitable exemptions in lots of different contexts that are in some ways hiding in plain sight. Blackstone talks about the role of courts in accepting circumstances that the legislature wouldn't really have intended. And Plowden explained in 1574, sometimes the sense and the reason of the law is not as large as the letter. And I should say here, when I talk about exemptions, I think really what I mean is often you are reading statutes that the plain language could apply to circumstances. You are not allowing the statute to apply to that circumstance that would fall within the plain language of the statute. You are saying that the application should be narrower than the language would allow for certain reasons. So in England, this equitable form of interpretation, which shouldn't be confused with differences of remedies of equity or law, it was just a form of statutory interpretation, in some ways was a power grab by the judiciary, because the judiciary was doing this given that there was this understanding of parliamentary supremacy and Parliament could do what it wanted. And so the judiciary was sort of straining in some ways to avoid unjust results or results that conflicted with other sorts of common law norms that Parliament really could accomplish if it was just being clear enough. But in the early Republic, I think that the role of equitable interpretation early on changed. There, the judiciary was often straining to just not declare that a law was void that Congress didn't have the authority to pass because of our strict constitutional limits and our rejection of the idea of parliamentary supremacy. We have examples of Justice Story talking about how courts should basically try really hard to interpret laws such that they weren't going to result in these sorts of conflicts. You also have this interesting quote from Chief Justice Marshall and Fisher, where he's talking about the context in which this sort of interpretation is important. And he says that it's when rights are infringed, when fundamental principles are overthrown, when the general system of laws is departed from. So there's some interesting things to think about as far as how equitable interpretation evolved over time. And I think equitable interpretation in some ways serves as a common ancestor for lots of different forms of modern judicial interpretation or canons of construction. one of which I think is modern as applied challenges. And we can talk about that more if that's of interest. But the bottom line is, for purposes of my paper, some of the implications that I think this broad norm of equitable exemptions highlights is that judicially created exemptions were a norm. It was not a constitutional anomaly. It would not have been a constitutional anomaly for courts to exempt from statutes protections for religious rights. Broad, generally applicable laws were often treated with suspicion, not deference, with the judiciary thinking the legislature was just being sort of sloppy or careless here when it came to conflicts with other sorts of higher law or fundamental law principles. And finally, that providing an exemption to laws was understood as being respectful to norms of the rule of law, because it meant that the judiciary was not striking down the law wholesale. It was trying to have a more targeted, sort of surgical solution for a particular conflict, while still not saying that the legislature had meant to do something contravening its constitutional authority. I'll go ahead and pause there.